Welcome to the first session of Legal Tuesdays, our series looking at key legal concepts and issues arising in the film and television industries. I'm James Whitaker and I act as legal advisor to the film and television charity. So in this first session and in the next two, we'll cover relatively briefly the topic of copyright, which is of course fundamental to anyone working in the creative industries for all sorts of reasons. And we'll look at issues such as what copyright is, when it arises, and how it can be infringed. So what is copyright? Well, it's one of the main types of intellectual property, which is recognized as a concept the world over, and it aims to protect the creators of content from others using or copying that content without the appropriate permissions or authorizations. Let me start by looking at what falls outside the scope of copyright protection. Anything that is in what is described as the public domain, either because the source cannot be copyrighted or because the rights have lapsed, will not be protected by copyright. Facts cannot be copyrighted and neither can ideas. The main source of copyright law in the UK is a statute called the Copyright Designs and Patents Act, or CDPA. But the UK is also a party to various international copyright conventions. Now, copyright protection is available for most created content. The main types of work that can be copyrighted include, for our purposes, literary and dramatic works, artistic works, musical works, film and broadcast, and sound recordings. You should note that characters, provided they are developed to a sufficient degree, are independent creations capable of copyright protection. When does copyright protection arise? Well, it arises automatically. It is said to subsist when a qualifying work is created. Now, it's important to remember that copyright will not protect an idea, only the expression of an idea. What that means is if you have an idea, no matter how good it is or how well developed and thought out it is, it will not benefit from copyright protection unless or until it has been expressed in some form, probably in a writing. Now, in order to qualify for copyright protection, the work must be original. It must have originated with the author, who must have used some degree of skill or judgment in its creation. Merit is irrelevant here. Ordinarily, copyright will vest in the creator of the content. Keep in mind, though, that an employee who creates content within the course of their employment, for example, a scriptwriter who produces scripts under contract for a studio or a production company, will not own the copyright in that content. The employer will. In the UK, and indeed in the US, copyright protection lasts for the life of the author plus 70 years. Once that period expires, however, the copyright lapses, the work is unprotected, it's in the public domain and is free for use by the world. Copyright is a proprietary right and it can be dealt with like any other proprietary right, which means that the owner can assign it, so they can sell it, or they can license it, and I'll talk about both of those in a later session, or it can pass under will. If someone uses a copyrighted work in an unauthorized way, that's copyright infringement. Primary copyright infringement occurs when a person other than the copyright owner carries out any of a number of prohibited acts with regard to a substantial part of a protected work without the authorization or the consent of the copyright owner. For example, copying a protected work. This occurs when there's found to be a substantial similarity between substantial parts of the two works in question. Both those concepts are tricky to define, but you get the idea. There are some limited exceptions to the prohibition on using copyright works. For example, the doctrine of fair dealing or fair use in the US, which essentially allows for the use of copyright works in limited circumstances such as non-commercial activities, including education or review and criticism, provided that the work is used genuinely and fairly for those purposes. And that's it for the first session of Legal Tuesdays. I look forward to welcoming you next time when we'll continue our canter through copyright. See you then.